The doctrine of notional extension means that work can stretch beyond the office or factory to nearby places and times closely linked to job duties. It protects worker when accident happen while entering or leaving the workplace or during necessary work travel if there is a real connection to employment. The key question is whether the injury arose out of the job related risk and happened in the course of employment activities. This approach aligns the law with everyday working conditions like gates, pathways, and employer arranged routes. It helps ensure fair compensation for genuine work risk. Even just outside strict premises of shift hours, it is a worker friendly principle built into India compensation framework. Statute explanation. The statutory anchor is Section 3 Class 1 of the Workmen's Compensation Act 1923. Now the Employees Compensation Act, which grants compensation for personal injury by accident arising out of and in the course of employment. This twin test is what courts operational through national extension, reading course of employment to include reasonable incidents of work in time and place.
Going to see about the essential in details. Accident. An accident must be a sudden towards event causing harm as opposed to routine strains or trivial discomfort. This differentiate compensation mishaps from the ordinary fatigues or common workplace wear and tear. The event's unexpected characters and casual potency are central to qualifying as an accident. Personal injuries. The injury may be physical or psychological, but it must be substantial enough to impair functions, earning capacity, or quality of life, and it must be attributed to the accident. The doctrine does not extend to the de minimis harms arising out of employment, a casual nexus. The employment must create or material heighten the risk that caused injuries forming a real causal bridge between the job condition, duties, and the accident. The Indian discussions emphasize that mere negligence by the worker ordinarily does not defeat the claim unless it crosses into exclude willful misconduct. The inquiry remains whether the risk was an incident of employment. In the course of employment, time, place, purpose, the nexus. The accident must occur within the continuum of employment related activities assessed by the proximity in time, place, and the purpose to duty. The notional extension treats necessary, assess, and agrees. Employers control require routine and duty mandate travel as with a reasonable pre-number of employment through each cases turns on specific facts. Next, exception in details. Short duration disablements. Statutory schemes may exclude very brief disablement, example less than 3 days. Channeling compensation to injuries with tangible work impact. Always verify the applicable thresholds and schemes. Willful misconduct bars. Compensation can be denied where the misconduct is of the exclude kind, such as intoxication, deliberate and knowing breach of the explicit safety orders or tampering or removal of safety devices, conduct that insert a new personal peril outside and the accepted employment risk. The focus is on the willfulness and the clarity of the safety prohibitions, public places, injuries lacking nexus. When a worker is exposed to the risk as a member of the public without their job related purpose, such as an unrelated personal detour from the unreasonable or reasonable route, the notional extension ceases to apply because the employment link is absent. Arising out and in the course of employment. Arising out of. Ask whether the employment created or materialized increase the cooperative risk? If yes, the casual limbs is satisfied subject to exclude willful misconduct. In the course of ask whether the time, place, and the purpose align with the duty or it reasonable incident, entry, exit, shop, pre, post, duty windows, employer, require or integral travel tested case by case for real substantial connections.
Of notional extension in India. The doctrine of notional extension is applied in a worker friendly way to cover accidents that happen just outside the workplace or during necessary work related travel. As long as there is a real link to the job, it is recognized under the Employees Compensation Act and the ESI Act, and courts look at whether the job created or increased the risk and whether the time, place, and purpose of the activity were closely tied to duty. Courts have also clarified that simple negligence by the worker usually does not defeat his claim if the accident arose out of and in the course of employment. Overall, the approach is to interpret the rule broadly to ensure fair compensation for genuine employment linked risk. Divorce Law and Others vs. Oriental Insurance Corporated Limited 2025. Facts: a night watchman of a sugar factory died in a road while commuting on his personal vehicle to report for 3 a.m. to 11 a.m. shift. The commissioner awarded compensation and interest with penalty on the employer, which higher farmers later dispute before the Supreme Court restored coverage issues whether a commuting accident occurring at the time and on a route assigned with duty arose out of and in the course of employment under the EC Act and whether ESI Act section 51E logic applies to EC Act claims. Law: EC Act requires the dual nexus. The court treated ESI Act section 51E as clarified and interpretation across statutes with identical nexus, language and social welfare aims. Analysis: the employee's presence on the road at that early hour was dedicated by duty. There was no unreasonable deviation or personal. Thus, a notional extension in time and place applied integrated ESI Act into EC analysis. Conclusion: community accident covered compensation payable. Under the EC Act, the ruling moves beyond the factory gate view and obliges employees and insurers to factor commuting risk where a clear nexus exists.
Ram Rao Ring Raji vs. Indian Yarn Manufacturer and Co. Discussion of authoritative commentary. Fact: an employee operating machineries was injured. The employer argued breach of safety instruction to resist compensations. Issues: whether the alleged disobedience, negligence by the worker defeat compensation when the accident still flows from an employment risk. Law: under the EC Act, injuries must arise out of and in the course of employment. Mere negligence ordinarily does not bar recovery unless an amount to exclude willful misconduct. Example: intoxications, preserving coverage for employment origin risk. Analysis: the operative risk was inherited in the machinery operations. The accident's casual core reminder employment related disputes and the alleged lapse. Statutory exclusions were not triggered. Conclusion: compensation sustained. The case shapes the arising out of limb by distinguish simple negligence from the willful misconduct, maintaining protection when the employment nexus persists.
In our opinion of this topic, I am going to talk about a illustration. Fact: a government school receives monthly home visits to meet parents of irregular students. During duty hours, a teacher cycles from school to three assigned homes on the shortest road. Carrying only school records on the way to the second home, a stray dog chases the teacher, causing a fall and wrist fracture. There is no personal data and the route and time match the official roster. Arising out of the employment. The trip happened only because the school ordered home visits, so the road risk came from the job field duty. In the course of employment, it occurred during duty hours on a reasonable route while doing an official task, so time, place, and purpose fit the job. Notional extension. Even though it happened off campus, the law treats necessary work, travel, and task as part of the job for this purpose. Outcome. Compensable. The injury happens in the course of employment. Only a big personal debtor or serious misconduct would usually break this link.